Hey guys, I'm gonna go over the 6 case studies I did for extra credit. Sorry, I'm doing this on my phone for YouTube. Alright, so excuse my voice. I'm still getting over bronchitis, but I'm gonna get right into it. So the first case study I did was Wood versus Boyden, and this is the Wisconsin Supreme Court. And the issue is, can a party rescind a contract for the good of sale or sale of a good when she cannot establish either fraud or mistake? And I basically wrote all these down. I had my real mom tell me that the Iraq method is a lot easier if you write them down and then review them. But anyways, the rule of law was a party may rescind a contract for the sale of a good if she can establish either fraud or mistake. So the analysis, basically what it goes into is, what is the plaintiff? Boyden is the defendant, and Boyden is a jeweler, and he was gonna repair Wood's jewelry, but he basically asked if Boyden knew anything about a stone that she had. Wood told Boyden that she'd been told it was topaz, and Boyden replied it probably was. At first, Wood refused because she only said, "I'll give $1 for it," but she decided to sell it. Later, Wood learned that it was what did it say, $700, and Wood tendered the dollar plus interest to Boyden and demanded the return of it. And at the time of sale, Boyden was not an expert in uncut diamonds, had never seen one before, and it did not occur to him at the time of sale it might be a diamond. But the conclusion is the seller might rescind the sale of a good and title and will reinvest it if, number one, the buyer was fraudulent in procuring the item, and number two is if the seller made a mistake and in delivering the good and that good was not sold. The last one I was talking about, it basically exists if there is a mistake in fact about the identity of the good sold and when it was delivered. In such a situation, there is not technically a rescission of the sale because title never actually passed to the buyer. But regarding fraud, inadequacy of price alone is not efficient to establish fraud. There also must be some evidence that the parties were not ignorant in the transaction, and then additionally, there was no mistake about the identity of the item that was sold. Wood presented the stone to Boyden, which she paid for, and she delivered. There is no evidence of a mistake. Accordingly, the judgment of the circuit court is affirmed. All right, that's the first one. The second one is Uber Technologies versus Heller. Pretty sure this is Canada Supreme Court. This one was a lot harder for me, and I actually tried to get my mom to help me on this one, and she's never seen a case study in Canada, I don't think, at least. But the issue is whether proof of inequality renders a contract unconscionable. The rule of law is unconscionable, decisable contract requires proof of inequality in the position of the parties and proof of an improvident bargain. So, David Heller entered into several agreements with Uber Technologies and its affiliates, which is Uber, in order to access Uber's rider delivery software. Agreements contained arbitration clauses requiring mediation and then arbitration. Heller sought to bring a class action on behalf of Uber drivers seeking, among other remedies, a declaration that him and other drivers are employees of Uber and therefore entitled to benefits under the ESA. Uber moved to stay the legal proceeding in favor of arbitration. On the first branch they did tests that appears to determine whether a contract is unconscionable. I can't say that word today. The test requires proof of inequality in positions of the party and proof of an improvident bargain. The first branch of the test The majority court found that there was an equality in bargaining power between Uber and Heller. The second branch of the test, the majority considered an improvident bargain to be one that, in the court's view, unduly advantages the stronger party. So, in conclusion for this case study, it is no longer necessary to demonstrate either objective or constructive knowledge of a counterparty's vulnerability or an element of intentional advantage taking before invalidating an agreement. In order to avoid a finding of invalidity, the majority encouraged drafters to make them more accessible to the other party or ensure that they're not so lopsided as an improvident or both. Did not know what the word improvident meant until my stepdad, he's a lawyer too. He explained what that meant. He explained what was the other word in this case study I did not understand. Arbitration. Well, actually, I learned that from class. But anyways, the next one is Bombin versus Southwest Airlines. The issue is a contract violated when flights are canceled and refunds are not offered due to a pandemic. So, the rule, law, and analysis for this is a little different. The analysis says Southwest Airlines canceled flights that would not be profitable due to COVID-19. A person who was affected by that, Adrian Bombin, was personally affected whenever his flight from Fort Lauderdale, Florida to Havana, Cuba was canceled and his request for a refund was denied. Southwest did not offer him an alternate flight and did not issue him a refund either. But he was given a credit toward a future flight. The plaintiff was trying to seek class certification on the basis that the proposed class members include people throughout the United States that are so numerous and geographically dispersed that joint deer would be impractical. All the exact number of case members is unknown. The plaintiff alleges the class may compromise hundreds of thousands similarly situated Southwest customers. Yeah, this was a harder one. The conclusion was basically that. Hold on. I just deleted it by accident. Yeah, so, sorry, back on track. What else did I write down? Alright, sorry. We're gonna come back to this one. The Caldwell versus Life Ends. This is, where was it? South Carolina. This is North Carolina. Alright, so the rule of law for this one is if a contract for life insurance is entered into due to a false representation, the contract is considered breached. So the issue is, does false representation negate a life insurance contract and entitled to the holder of the policy to compensation? So the rule of law for this, misspelled that word. Okay, so the jury had a bunch of information, found facts as testified. The plaintiff is admitted that the policies do not entitle her to receive the amount paid in or any amount at the end of 10 years. That, on the contrary, she forfeits all that she paid. Upon the verdict, the law declares that as she cannot have what she's promised, she must have her money back with interest if the defendant had been compelled to carry the risk. Sorry, I'm trying to rush this because my voice hurts. Where was I? If the defendant is compared to carry the risk during the life of the policy without compensation, must look to its accredited agent whom the jury find made the false representation. That's a long analysis, but basically, plaintiff alleges that sometime during the year 1895, she was induced by the representation made to her by defendant's agents to take out policies upon her own life. She demands the return of the money paid by her. Defendant company denies material allegations to the compliant. Anyways, they said that she failed to pay the premiums in accordance with the terms. The conclusion for this was where an illiterate woman was reduced to take life insurance out by agents' representations that she could draw out her claim at the end of 10 years, wherein the fact the policy is written gave her no such privilege, and she couldn't, on discovering that fact, that where was I? Recover the money and pay the premiums. And in action to recover an amount paid as insurance premiums on the. I'm sorry, I don't feel too good. To the effect that if plaintiff paid the premiums after having asserted the policy that she was not contracted for, she did not raise the question of fraud unless she paid the premiums under protest, which I didn't know this word either. Erroneous. It's not based on the evidence. Where there was evidence that the plaintiff first learned that there was something wrong with her policy, she endeavored without success to the matter, adjusted, and went from one agent to another in her efforts to obtain satisfaction until her policy was finally canceled. It's the last one. Yeah, this one is a lot shorter than the rest of them because I started getting really tired around this one. And I didn't find as much on this one and the bombing as the other three. But, alright, let's just get into it. This is the Bushel versus Bishop. And basically, the issue is an employee who is discharged entitled to an injunction against employer for a breach of contract. The rule of law for this one is an employer may discharge an employee, and if the employer is solvent, the employee is not entitled to an injunction against the employer for a breach of the contract in the absence of other equitable grounds. Just 1 second, I need a sip of water. So for this one, where the relation of landlord and cropper does exist, the landlord cannot be enjoined from taking charge of the crops. Alright, the analysis, the parties entered an agreement whereby one of them was to supply a farm, the seed, and the other was to supply the labor and tools necessary to harvest crops. Prior to the crops being harvested, the landlord organized a mob and attacked the cropper. Cropper suffered a beating and was shot. Court affirmed the order that issued a temporary injunction against the landlord. And the court held the trial court did not abuse its discretion, and when it was issued, the order enjoining the landlord from entering the cropper's property and take the crops. The court reasoned the landlord had no authority to use force to compel the cropper to flee the land and crops. And then the conclusion is pretty simple. It says when an employer is also a landlord of a cropper, the landlord may not force to compel the cropper to leave his lands and crops. Alright, so I'm going to really quickly circle back to the bombing one, because that one I didn't find the conclusion as easily as the other 4 or 5. But yeah, basically I'm reading up on it now. Yeah, but the plaintiff, on behalf of himself and all the other classes, hereby demanded the trial by jury on all issues. And it goes on for that and that and that. And then that's about it. Alright, so I am gonna attach some of these and then some of this video, and I hope y'all have a good night.